Dear friends, welcome to another episode. In this video, we address a topic that is, to say the least, unusual: the Iranian regime's imposition of tolls on ships traversing the Strait of Hormuz, and why President Trump is so incensed about it. Iran has begun treating the Strait of Hormuz as a sort of toll road, and the sums involved are not trivial, approximately $2 million per ship. A supertanker carrying around 2 million barrels of oil ends up paying close to $1 per barrel to traverse a natural strait that has been used for millennia. The proposal, in fact, has already been formalized. On March 30th, the Iranian parliament approved the so-called Strait of Hormuz Management Plan. Under the stipulated rules, vessels must submit a range of information, such as ownership documents, flag registration, cargo manifests, destination ports, crew lists, and tracking data, which is processed through intermediaries linked to the IRGC. Upon payment, which can be made in Chinese yuan via the SIPS system operating outside the SWIFT network, or in cryptocurrencies, the ship receives a passcode via VHF radio and is subsequently escorted by the IRGC Navy. The transit takes place through a corridor located north of Larak Island, diverging from the customary route, which lies to the south. There is also a tiered fee structure. Iran has established a 5-tier system based on nationality. Countries considered allies such as China, Russia, India, Iraq, and Pakistan end up paying lower rates. Ships associated with the United States and Israel, however, are simply denied passage. The central question is this legal? The straightforward answer is no. The imposition of tolls on a natural strait used for international navigation directly conflicts with core principles of international maritime law. The legal basis for this discussion lies in the United Nations Convention on the Law of the Sea, known as UNCLOS, which entered into force in 1994 and is frequently described as the Constitution of the Oceans. Articles 37 through 44, situated within the section dedicated to straits used for international navigation, establish the regime of transit passage. The central tenet of this regime is found in Article 38, which specifically guarantees continuous and unimpeded passage through these strategic maritime corridors, thereby clearly limiting the ability of any coastal state to impose restrictions or levies that would undermine this right. All ships and aircraft are entitled to transit passage, and this right may not be interrupted or made conditional by unilateral measures on the part of the coastal state. Article 26 itself aligns with this principle by stipulating that charges may not be levied solely for the act of passage itself. Rather, charges are permissible only for specific services that are actually rendered to the vessel. In this context, there is no basis in international law for a coastal state to impose a toll on a strait of international use such as the Strait of Hormuz. Iran signed UNCLOS but did not proceed to ratify it. This, however, does not imply a license to act outside the bounds of these rules. The point is that the right of passage through international straits does not depend solely on the treaty itself. This right has also become established as a norm of customary international law, meaning it applies universally, regardless of formal ratification. In practice, this significantly weakens any argument for a legal exception and upholds the obligation to guarantee freedom of navigation through these strategic corridors. Therefore, transit passage is a right, not a granted privilege, nor an authorization subject to arbitrary conditions, nor a toll to be paid. Nevertheless, a comparison frequently arises, that of the Suez and Panama Canals. This analogy, however, constitutes a false equivalence. The central point lies in the very nature of these routes. Both the Suez and Panama Canals are artificial waterways, constructed by human hands and financed, maintained, and operated by state authorities, which establishes a logic entirely distinct from that of a natural strait historically utilized for international navigation. In the case of the Suez Canal, revenue can reach hundreds of millions of dollars per month, with supertankers paying fees that can amount to approximately $1 million per transit. Conversely, at the Panama Canal, tolls for large commercial vessels generally range from $100,000 to $300,000, though they can exceed the $1 million mark for larger vessels, such as massive container ships. The fundamental difference is that in these instances, the fees are directly tied to an artificial navigation system. They serve to support the construction, maintenance, and operation of these structures, including locks, dredging, pilotage services, tugboats, and all the infrastructure necessary to facilitate transit. It is akin to paying a toll on a highway built and maintained by a third party, which entails constant costs for upkeep and operation. The Strait of Hormuz, on the other hand, follows a completely different logic. It was not built, excavated, or financed by any state. Rather, it is a natural geographical formation that has existed for millions of years and is integrated into international maritime routes. There is, however, an intermediate case that helps to better clarify this distinction. Turkey levies fees on the Bosphorus and Dardanelles Straits, yet this scenario differs significantly from the previous ones for several reasons. The primary point is that these charges fall under a specific legal framework, the 1936 Montreux Convention, which was negotiated multilaterally. This treaty establishes specific rules for navigation in the region, delineating rights and obligations, and authorizing certain types of fees within parameters previously agreed upon by the parties involved. Furthermore, the fees charged are relatively low, typically less than $6 per ton, which underscores the technical and operational nature of these tariffs. Another essential point is that there is a direct quid pro quo in terms of services. Turkey provides navigation support infrastructure, including traffic control, mandatory pilotage services, and continuous route maintenance involving dredging and constant monitoring. Consequently, this is not an arbitrary or isolated charge, but rather a regulated and functional system. This distinguishes it completely from a large-scale unilateral levy imposed under military pressure on a natural strait used for international navigation. If this type of charge were to become entrenched and come to be viewed as acceptable, the impact would extend far beyond a mere regional dispute. Global maritime trade relies heavily on narrow corridors, and approximately 80% of the world's goods are transported by sea. Within this system, certain points are particularly critical. The Strait of Malacca, situated between Malaysia, Singapore, and Indonesia, ranks first globally in terms of traffic volume, serving as the primary link between the Indian and Pacific Oceans. Any change to the rules there would have immediate repercussions for global supply chains. If a precedent were to be established in the case of Hormuz, other coastal states might be emboldened to adopt similar measures in their own strategic straits. This would trigger a cascading effect, fragmenting the rules that are currently relatively uniform under maritime law and introducing a logic of politically motivated levies on routes that, until now, have operated under the principle of free passage. In second place appears the Strait of Singapore, which, at its most critical point, is less than 2 nautical miles wide, making it even narrower than the Strait of Hormuz in certain sections, while simultaneously serving as one of the most congested routes on the planet. In third place comes the Strait of Hormuz itself, which already occupies a central position in global energy geopolitics due to the significant share of maritime oil transport that passes through it. From this point on, a hypothetical cascade scenario becomes evident. If the practice of levying unilateral tolls on strategic straits were to spread, the legal predictability underpinning global maritime trade would begin to fragment, paving the way for successive disputes at increasingly sensitive points along international shipping lanes. If this type of toll collection were to become acceptable in the Strait of Hormuz, the ripple effect would extend to other critical maritime trade choke points. This could open the door for China to attempt something similar in the Taiwan Strait, Indonesia in the Strait of Malacca, Yemen in Bab el-Mandeb, or even Morocco and the United Kingdom in the Strait of Gibraltar. It is precisely this risk of a chain of precedents that concerns the International Maritime Organization, IMO, as it would undermine the rules that currently underpin global shipping. And just when there appeared to be a consensus against this idea, an unexpected element emerged: President Donald Trump. When asked by an ABC News journalist about the possibility of accepting the imposition of tolls by Iran, Donald Trump gave an ambiguous response on April 8th, a moment that sparked significant international reaction just hours after the announcement of a temporary 2-week ceasefire. The following day, however, Trump backtracked, stating that such tolls were not part of any understanding and that Iran should immediately cease this practice. Concurrently, even Oman, a country situated on the opposite shore of the strait with direct interests in the region, denied any intention of adopting or supporting the imposition of transit fees. Direct negotiations between the United States and Iran are scheduled to begin on April 12th in Islamabad, Pakistan. In this context, Iran reportedly presented a 10-point proposal aimed at ending the conflict. Among these points is said to be the recognition of Iranian control over the Strait of Hormuz, along with the possibility of levying transit fees, justified as a means to finance post-war reconstruction. In economic terms, the potential impact is substantial. Under normal conditions, approximately 20 million barrels of oil pass through the region daily, which would translate into revenue of roughly $20 million per day. If LNG tankers are also included in the calculation, estimated revenue could exceed $800 million per month, approaching the revenue generated by Egypt from the Suez Canal. For the international system, however, the issue extends beyond the immediate financial impact. Accepting a toll collection model in the Strait of Hormuz would mean altering a core principle of maritime law that has underpinned global trade for centuries. In this sense, the outcome of the negotiations in Islamabad could ultimately serve as a turning point, marking the choice between maintaining freedom of navigation as an established norm or transforming it into an instrument subject to political and strategic bargaining. And if you enjoyed this video, don't forget to leave a like, and if you haven't subscribed to the channel yet, subscribe now and hit the notification bell so you don't miss any updates.